Good afternoon. We're thrilled to be presenting a timely panel entitled Coronavirus Protecting Safety Net Benefits During the Pandemic, sponsored by the American Bar Association and Civil Rights and Social Justice's Economic Justice Committee. This panel is one of many in a series of rapid response webinars on the COVID-19 pandemic. We are actively planning additional COVID-19 programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. During today's program, we encourage you to ask questions of our panelists. As an attendee, you should see a control panel with controls such as audio options, chat, raise hand, and Q&A. For the purpose of this webinar, we ask that you submit your questions through the Q&A, not the chat function. If you do not see these controls, please ensure your screen is not idle. We will address questions at the end of the panel. We will also be sharing a recording of the program to everyone who has registered so that you can share it widely with your networks. Please feel free to leave us feedback or ask questions to follow up. And with that, we're thrilled to bring to you today's program entitled Coronavirus, Protecting Safety Net Public Benefits During the Pandemic. My name is Jim Pearson. I'm the chair of the business programs at Chatham University in Pittsburgh and also serve as the vice chair of the Economic Justice Committee for the American Bar Association's section of Civil Rights and Social Justice. Our panelists that will be presenting today in the order of appearance are first, Joy Fowler, who's a public assistant applicant who has previously testified before Maryland legislature. Joy will provide her own story, but in short, she's a public recipient benefit in the state of Maryland who has tirelessly advocated for the rights and respect of the applicants and recipients of public benefits and the challenges they face. Joy has previously testified before the state of Maryland legislature, and we are grateful to have her with us today to share her perspective. Thank you, Joy. Our next speaker will be Elizabeth Lauer-Bash. Elizabeth is the director of the Center for Law and Social Policy, CLASP by acronyms, Income and Work Supports Team. In this role, she leads a team of experts focused on federal and state cash assistance, Medicaid, SNAP, and refundable tax credits and how they impact the lives of people with low incomes. Elizabeth has expertise in both federal policy development and an effective and cross-cutting implementation of federal policy. She also co-chairs the Protecting Immigrant Families Advancing Our Future campaign, which is a multi-organizational campaign dedicated to protecting access to income and work supports programs for immigrants and their families. From 1996 to 2006, Ms. Lauer-Bash worked for the Office of the Assistant Secretary for Planning and Evaluation at the U.S. Department of Health and Human Services. In this position, she was a lead policy analyst supporting legislative and regulatory processes during the implementation of the Temporary Assistance for Needy Families, TANF, the Block Grant, and managing research projects. Elizabeth has a bachelor's degree in history from Yale University, writing her thesis on pro and anti-immigrant tendencies in the 19th century American labor movement, and a master's degree in public policy from Harvard University's Kennedy School of Government. Elizabeth, thank you for joining us today. Our next panelist is Greg Bass. Greg is a senior attorney focused on disability rights. Prior to joining the National Center for Law and Economic Justice, Greg served as a litigation director at Greater Hartford Legal Aid for more than 16 years. He litigated, with help from NCLEJ staff, Raymond versus Rowland, a major class action under the Americans with Disabilities Act. After several years of negotiation and litigation, a $25 million settlement was achieved, which restructured welfare agency policies, regulations, notices, and staff hiring and training to comply with ADA. Greg also has litigated a number of other individual and class actions in state and federal courts across a range of legal areas, including Medicaid, housing, public benefits, consumers, employment, seniors, civil rights, and others. Greg's legal career of greater than 30 years has been devoted to serving as an attorney and managing attorney with legal services programs throughout the United States in Alabama, Washington, California, and Connecticut. He is a graduate of American University Washington College of Law, and we're happy to have Greg with us here today. And importantly, we have Michelle Solomon-Madeo, who's a senior attorney with the Economic Justice Project at the Homeless Persons Representation Project in Baltimore, Maryland. Michelle joined HPRP in 2013 to provide representation, advocacy, and education to clients on public benefit matters. Michelle is co-chair of Maryland's Legal Aid Statewide Public Benefits Task Force. Prior to joining HPRP, Michelle worked as a clinical law fellow with the University of Maryland's Carey School of Law's clinical law program, where she taught in a healthcare delivery and HIV/AIDS clinic, as well as the International Human Rights Clinic in Namibia, Sub-Saharan Africa. Michelle received her BA from American University and her JD from the University of Maryland Carey School of Law. From 2005 to 2006, Michelle is a Fulbright Scholar in Spain, where she researched the country's experience with citizens' juries over the past 10 years with the co-author of Spain's 1995 jury law. With that, we're grateful for Michelle and all our panelists to join us today and share their expertise. And what we'd like to do is begin by asking Joy to share her perspective. Joy, I'll turn it over to you at this point.
Hi, everyone. I just wanted to talk today about this. I've been using SNAP benefits for about 7 years on and off. I've always kept a job. It's just usually hasn't been enough to be stable enough independently. I do want to speak today about who this is really affecting. Could I have the next slide, please? Sorry, next slide, I'm sorry. Okay. So basically, I feel like it's the children who are really being affected. There's a lot of kids who their only meal was at school. There has been many people who I've reached out to who are receiving SNAP benefits, and they haven't gotten anything additionally for their kids or anything additionally at all. There has been even with some families, like families don't even know how to get access to certain resources. The parents, even if they even care enough to reach out to find more resources for their kids to eat. And you know, these kids, and another bit of people I think it's really affecting is the ones who are not very computer savvy. You know, even my mother, she has a very hard time getting into certain things online, and that's like the only way people can apply right now is online. They're not doing anything in person. So me personally, I have applied for SNAP benefits and TCA, and I haven't even heard back from them yet. The people also who are experiencing homelessness, I heard they were putting some people in hotels, but even then, kids still need food. And especially like the people with disabilities, you know, they need help getting their groceries, and the people struggling, you know, with mental illness, you know, that this could really be affecting them. And I also read about that 50% of the country doesn't have therapy and like psychiatrists because there's a shortage. And next slide, please. And I think that's the biggest thing is the resources for people. Even I've actually was homeless back in 2019, and I had multiple case managers, and the case managers didn't even really have resources. Like I ended up having to try to find these resources online by myself. So I really believe like that's a big problem too with the communication between these places that are supposed to help people in poverty. And that's another thing, you know, not everybody can afford a computer and have access to get on. I really feel like they should try to find another way to communicate. Can I have the next slide? Okay, and right now, I am actually not receiving unemployment. I had 2 jobs before this hit. I've lost both. I haven't gotten any SNAP. I tried to apply, even with the stimulus checks, like I got online, I had applied online, and they just kept giving me technical difficulties. I couldn't get through. I actually have a picture of that on the last slide of the messages I was getting. And for the unemployment insurance, you can only, you have to have had less than 3 jobs within 18 months, or you have to apply online. I mean, or you have to apply through phone, which that has been terrible for me. I've been calling up to 2 hours, 3 hours, just calling back to back, just busy tone. And I've had up to 5 jobs in 18 months. So I haven't been able to get through for that as well. So I think there's a big communication problem with all these benefits. Another big thing is I have been applying for other jobs. I have a 4-year-old son, and that's been really hard because his daycare is out. So that's kind of been another thing. Thank you.
Thank you, Joy. You have, and your last slide there was the difficulty you had getting in with the IRS and the IRS website as well for the stimulus check payment. Is that correct?
Yes.
Okay, very good. At this time, and what we'll do is we'll come back to Joy at the back end and get some additional perspective after we have some dialogue with our panelists. Elizabeth, at this point in time, let me turn it over to you, please.
Hi, thank you for having me. Let me see if hopefully you're seeing my screen now. I'm just going to very briefly go over the bills that have been passed by Congress and the new provisions that they have that have impacted the public benefits. As Joy said, definitely this is what's supposed to be available, and we absolutely recognize that there is far too much of a gap between what's promised and what people have been able to receive. But it's helpful as context to start with at least what's been offered. There have been 3 bills passed by Congress. The 2 that really matter for the benefits side are Families First, which was passed on March 13th, and then the CARES Act, which was passed on March 27th. As I think everyone probably knows, there's widespread recognition now that these are not going to be enough, and discussion about what more is needed. So, although in this slides I don't talk about what we think is still needed, certainly happy to share that if people have questions. So the first thing that Families First had is that it provided increased federal funds for Medicaid, a temporary boost in the matching rate that states could receive during the public health emergency. And that's actually worth lifting up because it will only last while the emergency lasts, the health emergency, and we know there's going to be an economic crisis lasting far beyond when the public health emergency may end. But the really strong thing about this is that it's conditional on what is called maintenance of effort, or MOE. And that really means that states can't kick people off of Medicaid while this is underway, which is incredibly important. The only exceptions are if people are voluntary asking to be disenrolled, or they're known not to be a state resident. And that does include if people have passed away. But states can't do what they sometimes do, which is when they send you a letter, and if you don't get it back in 10 years, they say, well, this must be proof that you've moved, and therefore we're going to cut you off. So some really important protections. States can't change their eligibility rules to make it harder to get on Medicaid, or create new or increased premiums, and no cost sharing for COVID-19 testing or treatment. People can't have to pay copays or deductibles for it under Medicaid. So these are really important protections for people who are receiving Medicaid. I will flag there's still gaps in who is eligible for Medicaid, but this is still a very important protection. On the SNAP side, Supplemental Nutrition Assistance Program, nutrition benefits paid through an EBT card. The law suspended implementation of the 3-month time limit for unemployed workers without children. So a lot of people otherwise would have lost their SNAP benefits because they couldn't work, which is always an incredibly perverse requirement, but particularly in a moment when people are being told to stay home and not work, would have been incredibly counterproductive. And it authorized states to issue emergency supplemental benefits to top people off. FNS is currently approving this for up to 2 months, but the only 2 months isn't in the statute. And at this point, we're expecting that that will be extended. And almost all states have adopted this. So if you were getting SNAP and you were getting less than the full benefit, states are lifting you up to the full benefit for your family size. One problem with this is if you are already receiving the maximum benefit, you don't get anything more, the way NFNS has interpreted this. The legislation also gave states just a great deal more flexibility in SNAP, recognizing that many offices are in fact closed for in-person visits and there's increased need. The bill gave states broad flexibility to extend certification periods, adapt their telephonic signature so you can apply without signing something and mailing it in. Usually, if you say you've lost your job, they either need something saying you've lost your job, or they'll call your employer and get them to say, yes, they lost their job. No one's answering their phones to answer those questions now. So FNS has said states can treat a stay-at-home order as the evidence that they need. So things like that. But again, it doesn't go as far as we think it should. There is no disaster SNAP, which is an option that would allow it to reach people who were not otherwise eligible for SNAP in some circumstances. No waiver of the student eligibility requirements if you're a college student at least half time. And you have to be working as well to get SNAP benefits, or caring for children, or some other requirements. Again, lots of people who are working and going to school have lost their jobs. In some cases, they may be losing their SNAP benefits as well. Child nutrition programs. The Families First had waivers that allow for online or phone applications for WIC, which has never been allowed. This is the special supplemental nutrition for women, infants, and children. Usually you have to go in person, you have to have a health examination to qualify. They're allowing for people to apply by phone, just to say, yeah, I can weigh my kid and tell you how much they weigh, instead of coming into an office when people, again, are being told to stay home. Schools are offering grab-and-go meal options for school meals. Childcare providers can also do that if they have the capacity, but we know that only a tiny share of the kids who would have been in school are actually receiving the grab-and-go meals. There's an option called pandemic EBT that lets states actually put more money on people's SNAP cards to replace the school meals. It's a really great option. because again, if you can't go, if you're still working or if you don't have a car, you might not be able to do a grab and go meal, but if you can pay for food on an EBT card. But even though this was in the bill that was passed over a month ago now, only 6 states have been approved so far. As Joyce said, Maryland is not one of them. So it's rolling out more slowly, but it can be a really important way. And also families who are not receiving SNAP, who are only receiving school meals, can get it as well. Everyone's heard about the economic impact rebate, which is the IRS's official term for what most people are calling the stimulus payments. It is $1,200 per qualifying adult, $500 for a child under 17. There are restrictions. You have to have a social security number to qualify. And if one spouse has a social security number and the other has an ITIN, unless they're in the military, an ITIN is what immigrants who don't have a social security number can use to file their taxes, the whole family will lose the benefit. You're not eligible if you can be claimed as a dependent by someone else. So students and other adult dependents, mostly people with disabilities, they don't count for the child benefit and they also can't claim their own benefit. So they get caught in between. It is based on your 2019 tax return if you filed. It's based on the 2018 return if the 2019 hasn't been filed. And if you don't need to file your taxes because your income is too low, you have to fill out a special form to get it. This is the IRS website. Joy did show some of the error messages that lots and lots of people have been getting. I've also been told that this is not well designed to be navigated on your phone, that it has pop-up windows, which mobile devices don't handle well. So again, it's lots of implementation challenges. Just flagging that they have said that if you get Social Security, SSI, or some veterans benefits, recipients will get it automatically. Others do need to either file taxes or fill out the form. It is important that it's not counted as income for other benefit programs or assets for 12 months. So you shouldn't lose your SNAP or your Medicaid or anything else because you get it. It can't be intercepted for most debts, but it can be intercepted for child support payments owed, which we know will affect a lot of people. And also we've been hearing some disturbing stories about banks claiming it after it's been deposited to pay for previous debts or other obligations. And that's really not what this was intended for. It was intended to put money in people's pockets right away. I will flag that immigrant families are one group in particular that was left out from a lot of the services. There is some relief for immigrant families. Immigrants who have Social Security numbers, including DACA recipients and TPS holders, are able to get the stimulus payments and in many cases unemployment insurance. Pandemic EBT and the WIC provisions can help immigrants and their children. But Medicaid and SNAP both have underlying restrictions that even many lawfully present immigrants are denied access for 5 years after arrival, which has, and folks who are undocumented do not have access to them. And that has serious implications for access in spite of the legislation that's been passed. And also, the administration has been working for 3 years to frighten immigrants away from receiving these programs with what's known as the public charge regulation. And the result is there's just a lot of fear and confusion and people don't know what they can and can't safely receive. And again, as I mentioned, the on a stimulus payment, economic impact payment, if you don't have a Social Security number, you're not eligible for it. And this will result in an estimated 2 million US citizen spouses and 4.1 million US citizen children in mixed status families being denied the benefits, in addition to the individuals themselves who are not citizens. So half empty, half full, some important provisions, but there's definitely a lot more that needs to be done. And I know Greg's going to talk a lot more about the unemployment insurance and paid family leave provisions. Again, really good intentions, the first national paid leave legislation we've ever had, but really complicated, kind of hard to figure out which program you should be eligible for, when, and how to get it. So with that, I will pass it back to Greg, and then happy to answer questions at the end. And I need to figure out how to do this.
Great. Thank you, Elizabeth. And at this time, Greg, if you'd like to share with us your material, that'd be great.
Let me move up to the start. Hi, everyone. Thanks to the ABA and thanks to everyone who's attending the webinar. We really appreciate it. I'm going to touch on a few topics, first focusing on unemployment compensation benefits, and then I'm going to do a pivot to basic access issues that run across the board for public benefits programs and provide some outright obstacles to, as Joy has already illuminated very well, to public benefits eligibility and access during COVID-19. Part of what happened under the CARES Act, which was signed on March 26th, nearly a $2 trillion economic stimulus package, was the enactment of 3 basic new unemployment insurance programs to meet the pandemic. The CARES Act creates the Pandemic Unemployment Compensation Program, which is an additional $600 per week on top of regular benefits to all UI recipients. It also creates the Pandemic Emergency Unemployment Compensation Act, which is an additional 13 weeks of UI benefits beyond the usual regular 26 weeks that folks typically get. It finally creates the Pandemic Unemployment Assistance Program for individuals who have traditionally been ineligible for UI benefits, who have been carved out of those programs state by state. Now, the Pandemic Unemployment Compensation Program, it temporarily supplements UI benefit amounts and extends the duration of those benefits through July 31st, 2020. All regular unemployment insurance, Pandemic Emergency Unemployment Insurance, and Pandemic Unemployment Assistance Program claimants will receive their usual calculated benefit plus an additional $600 per week in compensation. This is a flat amount paid on a weekly basis, and it's not income for purposes of Medicaid or CHIP, Children's Health Insurance Program benefits. One problem with that is that the federal legislation does not mention SNAP food stamp benefits, so there may be some issues with income counting for purposes of eligibility for SNAP. If you're already receiving unemployment insurance, to get your $600 a week, you don't have to do anything. You don't have to make an additional application. It'll already be automatically added to your regular benefits. It will not reduce your ongoing unemployment benefits. Now, the Pandemic Emergency Unemployment Compensation Program is an additional 13 weeks of state unemployment insurance benefits. Most states offer 26 weeks typically. To receive PEUC, you have to be actively engaged in searching for work, but the CARES Act does specify that a state must provide flexibility in meeting work search requirements in case of individuals who are unable to search for work because of COVID-19 conditions. There's also something called a non-reduction rule that's coupled with PEUC. As long as states are participating in this program and the other unemployment insurance programs enacted under the pandemic, states may not decrease the maximum number of weeks of UI that are typically afforded under their program or the weekly benefits that are available. In terms of a waiting week, most states have a statutory 1-week waiting period for people to receive UI benefits, but under the CARES Act, states that waive the 1-week waiting period will be fully reimbursed by the federal government. So what that's meaning is that states are basically waiving this 1-week waiting period. Even if you've exhausted your UI benefits a while ago, you're still eligible for PEUC. Anyone who exhausted their benefits after July 1st, 2019, last year, you can still get your 13 additional weeks. And on top of that, you will still get your $600 a week direct payment. Now, the Pandemic Unemployment Assistance Program, this is a new program that provides emergency of PUA are available to workers who are immediately eligible. The program will expire on December 31st of 2020. A fundamental feature of this program is that it gives income support to many workers who are usually shut out. This can involve self-employed workers, including independent contractors, freelancers, workers seeking part-time work, or workers who do not have a long enough work history. They can be eligible for PUA benefits. Workers are not eligible for PUA if they either telework with pay or they're receiving paid sick days or paid leave. This program will run from January 27th. It's already in effect. It can be retroactive through December 31st of this year. Now, the PUA benefits are calculated the same way as they are for the Federal Disaster Unemployment Assistance Program, which is this is basically modeled on. It'll have a minimum benefit that's calculated according to a formula, and it will have the additional $600 a week direct check. There is no week-long wait period. Now, PUA has some attached covered conditions. The good news is that applicants for PUA only need self-certify under most circumstances that they meet these conditions. They have to be partially or fully unemployed or unable and unavailable to work because of these various conditions. And I apologize, there's a lot of writing on this slide, a lot of small print, but it can be used as sort of a checklist. If you meet basically one of these COVID-19 related conditions, then you may be eligible for PUA. Now, access conditions come attached to unemployment insurance in a very specific set of ways under the Families First Coronavirus Response Act, or FFCRA. This took effect on April 3rd, and it provides $1 billion in federal funding to the states. It's divided into two $500 million tranches of funding. It basically is meant to meet the challenge of processing huge numbers of UI claims, and you're all seeing the reporting about this, resulting from the economic downturn that's precipitated by COVID-19. It advances a high emergency priority. This is according to the U.S. Department of Labor, of emergency administrative funding to the states to staff up to meet the massive increases in workload that are anticipated and that are in fact actually happening under COVID-19 and the emergency response and the economic downturn. States are already at historic low levels of administrative funding, so this is at least facially very well welcome to meet this historic low in administrative funding. Each state's share of the $1 billion distribution is determined by the federal funding formula based on taxes collected. It ranges from a high of $118 million for California to a low of $1.77 million for Wyoming. The federal law does not require state legislatures to do anything. They do not have to enact legislative appropriations. The money will automatically be activated. Significantly for our purposes here today, the federal funding is conditioned on compliance with some basic standards. Some states are already meeting these standards, but some are not. The idea is to ensure that benefits are fairly administered and certain minimum steps are taken by the states to expand access to benefits. This is the basic access hook. Under FFCRA, there are certain specific conditions. The first phase of the law, this first $500 million tranche, talks in terms of employer notification, alternative filing options, and state notification. Employer notification, the law requires states to have in place a requirement that employers notify individuals of the availability of UI benefits at the time they separate from their job. DOL has provided a model notice, but advocates may want to try to have some input on this to tailor it specifically to COVID-19. These notices should reference the availability of UI, these expanded programs when somebody separates from employment, these programs that are in response to COVID-19, and any guidance that the state has developed in that notice and those programs. Alternative filing options, this is key for some of the horrendous access conditions that you're seeing across the board in virtually every state. The state has to ensure, again, as a condition of getting this first $500 million, that applications for benefits and assistance with the application process are accessible in at least two of the following mediums: in person, phone, or online. Many states have shifted to online filing over the years, and some states have limited access to phone claim systems, phone-based. Most states no longer provide in-person filing options. Department of Labor has said just recently that for persons unable to access or use a web-based system, the state must offer an alternative option for processing information and benefits, such as in person or by telephone. Equal access has to be ensured. States have to have staff that are properly trained to provide this linkage to facilitate routine acceptance of information. So this funding is key to ensuring that workers, no matter their computer literacy level, their English proficiency, their disability, or other disadvantages, can readily access their benefits. For example, if the state only provides online processing of benefits and application, but refers individuals to a separate phone number for help with online filing, that may not meet the federal standard that's required by the law. And in fact, that's what a lot of states are doing. And that's a partial reason for why you're seeing such backups. Now, the third condition, state notification. The state has to notify workers filing for UI benefits when the application is received by the state and it's being processed. If there's a holdup to the processing, the state has to provide information and tell the worker about that, explain why the claim is not being processed and what can be done to speed it up. With COVID-19 related claims, workers may have trouble tracking down necessary information from employers who may no longer be in business or otherwise they're unavailable. Some states processing COVID-19 claims may require individuals to provide proof that they're caring for a dependent child whose school is closed. Getting information to verify that from the school can obviously be very difficult. Advocacy can help focus on getting states to streamline this sort of process and limit the additional proof that's absolutely necessary to process COVID-19 related claims for benefits. Now, briefly, the second phase of emergency administrative funding, the second $500 million, states have to certify a couple of things. They have to certify that their unemployment rate has increased by at least 10%. That's a trigger that they have to use. To then qualify for the money, the state has to express a commitment to maintain and strengthen access, basically to show that they're improving their state recipient rate of unemployment benefits. They have to demonstrate specific steps that they've taken or they will take to ease eligibility requirements and access. Now, this can involve several things: waiving work search requirements for COVID-19 claims, waiving the waiting week, and again, many states are doing this, relieving employers from being charged for COVID-19 claims, which would increase their UI tax rate. Now, the Employment and Training Administration of the United States Department of Labor talks about actively seeking work as a requirement that most states have for maintaining eligibility for benefits. States have to be flexible for this in the COVID-19 environment. There are also state laws that provide that you have to have good cause for things like when you voluntarily have quit your job, or you're trying to find suitable work, or you're able and available to work. States have to be flexible on that. This is the U.S. Department of Labor talking. Good cause can include leaving work due to a reasonable risk of exposure or infection, or self-quarantine, or to care for a family member affected by the virus. Now, this slide is from the New York State Department of Labor. It's a nice flow chart, very simple and very basic, that shows basic eligibility processes and patterns for the various programs created by the CARES Act. It's kind of a handy tool. You may encourage your states to use something like this. Now, Elizabeth referenced paid leave. Very briefly, the Families First Coronavirus Response Act requires certain employers to provide employees with paid sick leave or expanded family and medical leave for specified reasons that are related to COVID-19. These provisions will apply through December 31st of this year. Under the law, an employee qualifies for paid sick time if the employee is unable to work or unable to telework due to a need for leave because the employee is subject to quarantine, has been advised by a healthcare provider to quarantine, is experiencing COVID-19 symptoms and seeking a medical diagnosis, and related sorts of COVID-19 scenarios. The Act provides that employees of covered employers are eligible for 2 weeks of paid sick leave at a regular rate of pay for quarantine situations or experiencing symptoms. You can get 2 weeks of paid sick leave at 2/3 the regular rate of pay because of a bona fide need to care for someone subject to quarantine, care for a child whose school is closed, and up to an additional 10 weeks of paid expanded family and medical leave, premised on the Family Medical Leave Act, at 2/3 the rate of pay for someone who's been employed at least 30 calendar days and unable to work for a bona fide need to care for a child whose school is closed. Covered employers, basically private employers with fewer than 500 employees, are covered, but small businesses with fewer than 50 employees may qualify for exemptions from the requirement to care for a child whose school is closed. Now, using the example of SNAP, I'm going to talk real briefly about some basic access issues that are affecting not only SNAP, but other programs. The Food and Nutrition Service of the Department of Agriculture has this interesting document called the SNAP Pandemic Planning Guidelines. It talks about how the states need to plan for something like the pandemic. It provides direction on necessary preparation for the emergency situation, and it also gives, on the flip side, what are going to be inevitable access issues, some of which Elizabeth has already mentioned, and certainly Joy has talked about. Now, we're seeing the reported numbers, of course, of UI applications, the system's being flooded. This is happening for TANF cash assistance monies. This is happening for SNAP as well. In California, Vermont, and Washington, applications have more than doubled since the beginning of March. In Connecticut, as of March 30th, applications for food stamps rose from 147 to 453 a day. So the pandemic and the emergency response is going to have to meet this flooding. This pandemic planning guidelines document tells the states that first, you have to have a pandemic plan. Advocates should try to inquire whether or not your state has one. Capacity. State agencies have to assess their business processes, their technology, to ensure the systems are capable of functioning at the kind of levels they're already seeing. And this is real nuts and bolts. For example, is your mailed application system, mailroom, mail distribution, key entry of application data, can that accommodate the anticipated volume of paper applications? Call centers. Many states have regional or statewide call centers. What's the maximum volume of incoming and outgoing calls that your system can accommodate? What happens when the system is overloaded? Do you have interactive voice response functionality that allows clients to get general and case-specific information from workers who can talk to those issues? What about outreach? Does the state use robocalls to let people know about information about changes in policy or conditions of office closures, for example? Is there general outreach besides robocalls? How will agencies get the word out generally about changes that are instituted either officially or de facto to meet the pandemic? For example, in New York City, the Human Resources Administration has developed a downloadable application called Skip the Trip, a social media toolkit. And that allows organizations to develop tailored responses to outreach to get the word out. Systems and tech. Does the state have a web-based online application? Is this through a mobile application or a mobile-enabled website? Again, in New York City, they're encouraging increased use of their mobile application, Access HRA. Does your state have something comparable? Do you have online case management systems that allow households to do a number of routine tasks related to their SNAP case, for example, through a web-based portal, viewing case information, viewing notices, reporting change in household factors? Do your servers, your state servers, have the capacity to handle increased, sometimes dramatically increased web traffic? Staffing. Can you estimate what % of your workforce will be absent from work during various stages of the pandemic? Again, do you have a plan to meet those staffing conditions? Do you have case banking or electronic case files so you can move work from some offices that may need to close to other offices or to staff who are working remotely? Do you have telework policies and systems that allow telework to actually occur? These questions and instructions and mandates for agency planning, as I said, they anticipate on the flip side access issues that are inevitably going to come up. States need to be considering a range of options, allowing clients to file applications by mail or telephone or online. Develop mobile applications, substitute telephone interviews for face-to-face interviews. And some of this Elizabeth has already touched on. Maximize use of verification through online databases. Consider document imaging technology. Replace something that's fundamental. Let's replace aspects of EBT card issuance that are currently only available by distribution over the counter. Replace that, for example, with card issuance by mail. Some states don't have that, and they need to start considering that. In New York, the Office of Temporary and Disability Assistance has sent out general transmittals to offices around the state. Districts, local districts, each have to have staff available during core business hours, according to this transmittal from OTDA. Districts are not allowed to limit the days of the week or times of the day that a person can apply for assistance. Use of external secure drop boxes can be okay, but there has to be a way for someone to get a receipt when they drop off documents, verification eligibility documents in these drop boxes. An individual has a right to file an application with the district at any time during business hours. Basically, accommodations have to be developed to make these processes work. That's what New York State has instructed each of its county local districts. So what is your state doing? Now, processing delays, as folks know, federal law for SNAP requires that after the date of application, regular food stamps be provided within 30 calendar days. If you are a destitute household or an individual, it's 7 calendar days after application. COVID-19 is going to dramatically increase SNAP enrollments that are not timely processed. For a number of years since the Great Recession of 2008, we at NCLEJ have litigated a number of lawsuits that have challenged states' failure to timely process food stamp benefits. You're going to see that again. It's inevitable under COVID-19. untimely processing of SNAP benefits has resulted typically from a number of factors. Increased enrollments, you're certainly going to see that now. Loss of staff, loss of funding to various agencies around the country, and dysfunctional modernization efforts. Many states have upgraded their computer eligibility systems through private contractors. Problems have inevitably resulted. They've installed call centers. They've developed new business models about how eligibility workers do their job. Compound all of those factors with COVID-19, you're going to see delays. So hopefully advocates can monitor how their state is doing. Real briefly, a word about fair hearings and due process. Again, the example of New York, they've taken specific steps. They've issued a guidance in the form of a 6-month demonstration project, the OTDA Office of Administrative Hearings. They're going to try to ascertain the viability of doing fair hearings by telephone, video, or other means of communication. Obviously, in the context of COVID-19, this is to facilitate social distancing. So the current health crisis provides a platform for them using this demonstration project. In-person hearings will still be an option. You have to request it. OAH or the hearing officer can exercise their discretionary judgment to do it in person, or there may be other circumstances where due process requires that, density problems and social distancing problems aside, the hearing has to be done in person. This raises a number of nuts and bolts issues that if your state is trying to do something similar to reduce social distancing for in-person hearings, you might want to take a look at it. Again, the advocates in New York deserve a great amount of credit for putting these issues to the forefront. For example, if the hearing is going through a process of figuring out whether it should be in person or not in person, and the client does not appear, default should not automatically be taken. The hearing should be administratively adjourned until the process is sorted out. Well, administrative law judges or fair hearing officers have the ability to conference in several numbers if a representative or appellant needs to have a witness testify. Given the fact that staff are working remotely, ALJs and fair hearing officers are working remotely to greater extent, all of these issues come to the forefront. Notices have to explain what the options are that are available to both unrepresented appellants and to representatives. Submitting documents for hearings that are not conducted in person, there are a lot of issues that have to be sorted out. Do they use a dedicated fax number to introduce documents? What's the timeline for getting an evidence packet from the agency so that you can prepare and know what the agency's case is that they're going to present? How do you submit those documents yourself? By fax, by electronic submission? How do unrepresented appellants do that? If they're directed to use it by mail to submit any documents they may have, time delays are inevitable there, and that can create confusion. Administrative law judges and fair hearing officers should also be directed to keep the record open for submission of documents after the hearing is concluded. There are a number of due process issues that advocates may want to take a look at. Real briefly, this is a case study from a state that shall remain nameless. This came from a conference call that I participated in last week in the context of monitoring enforcement of a settlement decree. The agency had informed us that due to COVID-19, staff attrition rates in their offices were causing them to invoke an emergency code that would give them sort of a safe haven from timely processing of food stamp benefits. They've already closed 5 offices. They have skeletal staff in the remaining offices, and they're trying to get staff out of those offices. They're expanding telework for staff, but they have finite amounts of equipment. Unless staff have state-issued phones, they're uncomfortable doing things like interviews on their personal cell phones. Fewer staff in central locations are available to mail out documents. They're trying to relax verification requirements to their credit. They say that their call center is also functioning remotely, but it's hard to tell whether they're keeping track of things like wait times or abandonment rates. Documents cannot be brought in person by clients for verification purposes. They do have drop boxes, but it's unclear excuse me, where the clients will get receipts, but they drop those documents off. Outreach is a little unclear whether or not they're informing the public about all of these changed circumstances. Online or mail are the only ways that you can apply for SNAP. You're not allowing applications by phone. So their takeaway was that they're optimistic that they're maintaining timeliness. They don't appear to have a pandemic plan, which the feds have told them they need to have. So you might want to compare this sort of case study with what's happening in your state. And then finally, one word about applicants and recipients with disabilities. I wanted to end with a quick pitch for keeping in mind the needs of these folks who have to rely on subsistence level benefits and they have disabilities. There have been numerous studies since the 90s reporting significant percentages of cash assistance and SNAP recipients who have barriers, impairments, and disabling conditions. Title II of the Americans with Disabilities Act, it governs what public entities like public benefits agencies have to do to comply with mandates that have to do with applicants and recipients for benefits who have disabling conditions. Basically, one crux of that law is that these state agencies have to provide reasonable accommodations for persons with disabilities. They have to reasonably modify policies, practices, and procedures if necessary to avoid discrimination. This is changes in program rules or policy, changes in the ways that agencies do things, or changes in the ways that persons with disabilities can be allowed to do things. These are very fundamental, everyday street level things like rescheduling appointments, helping clients gather third-party verification, providing assistance, explaining and filling out complicated applications and other forms. Home visits may be a reasonable accommodation, providing sign language interpreters or converted documents in alternate formats for persons who are blind. The track record of state agencies without COVID-19 as a context is spotty at best in providing reasonable accommodations to applicants and recipients with disabilities. It will be greatly aggravated by COVID-19. This is personal interaction to make sure that people get reasonable accommodations. And there's a very great fear among advocates around the country that these folks will be left out in the cold. Thank you very much.
Thank you, Greg. That's very, very helpful. And I know you've got, is your son now out on the West Coast or not?
He is. He's at Portland, Oregon.
Oh, excellent, excellent. Well, he should be proud of an excellent presentation. So thank you so much.
Thank you.
At this point, let's go back to the East Coast and talk to Michelle from Maryland. And Michelle Medeo, if you'd like to share your screen and present, we'd appreciate that.
Thanks so much. Hi, everyone. Thanks for tuning in. Really appreciate it. I'm trying not to duplicate information already presented by the other panelists. So I was going to focus on what some things that advocates can do with regard to the temporary assistance for needy families benefit. TANF might be known in states as, in Maryland, it's temporary cash assistance. This, you can please go to the next slide. So TANF was not specifically, there was nothing additional, no additional funding for TANF in the Families First or the CARES Acts, like there was with the recession in 2008. But you know, besides reauthorizing it. But even though there wasn't additional funding, the U.S. Department for Health and Human Services, HHS, did put out some guidance talking about some things that states can do. And so I'm going to use Maryland as an example of some of the changes because there are things, I mean, we do need more funding, and I'll talk about that later, but there are some things we can do, states can do with TANF. So in Maryland, what some of the changes that came about, our TANF agency is called the Maryland Department of Human Services, so I might say DHS or the department to refer to it. Our department issued a 6-month extension on all redeterminations, so that way it aligns with the redetermination extensions that they also did with the SNAP benefit. there's a 90-day period where folks can provide verifications that the department might need to support eligibility. So typically, the department will give out, it's supposed to give a minimum of 10 days. We often see it giving out only a maximum of 10 days. So something like 90 days is very helpful right now, as Greg mentioned, with employers not either existing anymore or not responding to requests for verification to show you're still or you're no longer employed. Usually just the culture in accessing some of these benefits is that, anything you say, oftentimes, regardless of what the regs say, you in practice, you might need to provide a third-party verification just to back up what you're saying. So it's a very verification-heavy process. So there's extra time, and the 90 days, I believe, is from when you apply or when they need the verification or request it. There's a work activity requirement with TANF. So all eligible adults in the household, if they've been assessed and there's no good cause or exemptions, will be required to work as a requirement to receive the TANF benefits. So this requirement has temporarily been suspended. And in Maryland, they've aligned the suspension up with the closures of schools. They've also decided that they're not going to be sanctioning for noncompliance, which is great and also makes sense if we're suspending the work activity requirements. So typically, if a person who receives TANF does not comply with some aspect of the program, like child support, substance abuse, work activity, they could be sanctioned for noncompliance. And the sanction would, some states have partial benefit reductions. Other states have full family terminations, full family sanctions. Not allowing any sanctions during this time is a great step towards helping families access the benefits. In Maryland, sanction closures have always been the #1 reason that folks get their TANF benefits terminated. So prior sanctions in Maryland are not going to prohibit new applications from getting approved. So if your benefits at some point in the past closed out due to a sanction, you reapply, this can't be the reason that your application doesn't get approved. Another change is, granting the hardship exemptions for anyone who's already at the 60-month time limit. So TANF, there's a 60-month time limit. You can apply for a hardship exemption, or the state can give a hardship exemption. So Maryland's granting those. They've also asked HHS that anyone who's receiving TANF right now, that those months during COVID that folks are receiving, that it doesn't count against the 60-month time limit. So we can send out the HHS guidance after, or a link to it after, but it basically just says that states can grant some flexibility in the ease of requirements. It gives some examples like telephonic appointments to minimize the face-to-face interactions. It does say granting good cause from the work requirement, either because folks are ill, don't have childcare, work closed. So in Maryland, they did grant it good cause for everyone. You don't have to, it's not on an individual by individual basis. And so, what the guidance says is that while they don't have the authority to just completely waive the work activity requirement, they're not going to penalize states financially if the state wasn't able to meet the work activity or the work participation rate due to COVID. They're going to be granting what's called reasonable cause, and that they'd be liberal in granting it. So, in Maryland, our work participation rate is low, so we'll probably be fine even without it. But even if we didn't meet it, HHS has said it's going to be granting reasonable cause, so no financial penalty to states. Next slide. So, despite a lot of these, really great policy changes, we still have been seeing a lot of issues in accessing benefits, and it changes from week to week what we're seeing. So far we've seen, these are just some of them. There's a lot others, but incorrect benefit amounts. So if you've added a household member, or someone was born, or you lost your job and you had a change in income, not seeing a timely change to your benefit amount that would reflect that. We have still seen benefit terminations. Most of the ones we've seen have been pre-COVID notices going out before COVID saying, I should say not before COVID, before the departments closed to the public. So notices that went out saying, you must come in person to do a redetermination or to drop off this verification or whatever it is. And then the benefit, person wasn't able to because the office is closed, benefit terminated. There were a number of benefit terminations that, kind of like Greg talked about with the automated systems. So we have that in Maryland where, you can code a case to close that out, and unless you actually go in and manually undo the case closure, the case is just, even without further action, going to close out. So a lot of those, a lot of issues with applications. So folks getting denied beforehand, having to reapply. And we have seen, that even though a lot of these verification requirements are relaxed, or you have more time, or the phone interviews relaxed, or not happening, the processing of applications is still not immediate, even when all the information that the agency should need is right there in the application. Next slide. While I'm waiting for the next slide, we did see an increase in applications in March. There was, I think, almost a 30% increase alone in the applications received in March of 2020, and that's for SNAP benefits, as received in 2019. And there was more than twice as many new TANF household applications approved for so far for a specific period in February and March of this year as the same period in last year. So what that shows is, I don't know if you can, I can't see the slides on my screen. Not sure if we can pull them up. But so we're seeing families who never received TANF before applying and being found eligible, more than half. Allie, can you get the screens up, please? The slides, I mean.
I'm so sorry. I am having some issues. Hold on one second.
Thank you. Well, I'll just keep talking while we're I'll just keep looking. So I had a slide about, some different ways that advocates can connect with folks experiencing homelessness right now, and just sharing some of the things we've been doing. Oh, I'm sorry. Okay, I'm pulling up my own slides. Allie, can you let me know when they're up? I'm just going to look at my computer until they're up. So just some things that our local department has done to try to connect with folks experiencing homelessness. They did create a position, I'm not sure exactly what it's called, but it's like an ombudsman for folks experiencing homelessness. And so we've been able to directly communicate with that person, as opposed to, the long hold times that you experience when you call. So that's been really helpful. Our department has also been in communication with the Continuum of Care leads. And COC, or Continuum of Care, is regional or local planning bodies that coordinate housing and services funding for homeless families and individuals. Departments also had a weekly call with advocates where we can raise issues that we're seeing and try to get some direct responses and answers. We've also asked them to do some data searches to try to connect. So, on the online application in Maryland, I think there's a box you can check that either says homeless or no place to stay, or if you enter that in a field. And so you can do a number of data searches to try to pull the applications that have, where applicants have self-identified as experiencing homelessness on it. You can also pull like March and April benefit terminations and try to reach out to those families, or look at processing times. For emergency SNAP applications, you can pull applications where families have been sanctioned in the past. So a number of different ideas about just using data that the department already has to do searches to try to connect with families experiencing homelessness, or that were receiving TANF and were sanctioned in the last few months. All right, so just some lessons learned from all of this, and it, like I said, it's changing from week to week, but communication is really important. So if you're working with a department that has made a number of changes, it's really helpful to effectively communicate those changes. Through a lot of folks do have access to the internet, paper notices, signs. Okay. Messaging is really important too. So a lot of times there's this culture of, different jurisdictions operating as almost like, your experience in one county is different than the other, even though there's like a statewide policy that applies to all counties. So right now it seems like it's been helpful to frame all this as a unified state approach. So it's kind of all hands in. We're helping to connect as many folks to benefits as possible, regardless of, if one worker is working in a county remotely on an application, another. It's right now the focus is on getting everyone in Maryland who is eligible and applying for these benefits to be approved as quickly as possible. Something else that's been helpful has been framing in terms of public health. So, for verification, rather than requiring someone who says they have a disability to get on the bus, go to the doctors, get a piece of paper confirming exactly what they already said, we don't want that. We want folks to be able to stay home, stay healthy, stay safe. So we don't need that verification right now. We can still go ahead and approve without that. Similarly, when it comes to terminating benefits and sanctioning, that all requires a lot of administrative work. So to put a sanction on a case, then send a notice out saying the person's been terminated, only for them to reapply, a month or so later, and then wait and get approved. That's a lot of administrative work. So the department is saving itself time by not sanctioning and terminating folks, by just keeping folks on benefits. So I guess, okay, the slides are still not up. I'm just going to keep going through. So the next slide I had was a slide that it's a visual of like arrows shifting from a culture shift of one that relies, thank you, Jim. All right, I see them up. So we're on the culture shift slide. Thanks. So yeah, it's before COVID-19, the focus a lot of times just would feel like, there's just a heavy focus on the work participation rate and states meeting that. And so you would see the focus result in a lot of sanctions, a lot of terminations. And we're seeing these, obviously for folks who are actually eligible, who should never have been sanctioned or terminated. So unlawful, improper sanctioning and terminations, very little, if any, flexibility in program rules and verification requirements and things like that. And now we've seen a lot of that kind of shift with the department saying they're not sanctioning, they're not terminating, that they're going to grant flexibility, and the focus really being on trying to approve folks. So it'll be interesting to see eventually when offices reopen and some of the flexibility is lifted, if the culture shifts back to how it was before, or what, if anything, stays the same. There is also, there's been racial disparities in the TANF program since for a long time and still existing. Historically, as more Black families began to receive the benefit, public perception and the media, perceived TANF recipients as undeserving, lazy, unwilling to engage in paid work. And this contributes, of course, to the stereotypes we still see today. And if you look at the states that have more strict TANF requirements, it's states that have a larger percentage of Black families receiving TANF. So there's definitely racism that exists in the administration of these benefits historically and still at present. Will just be interesting to see what happens. Next slide, please. What happens when, a lot of the requirements that are relaxed are no longer. Just some things you can do to connect as advocates with folks experiencing homelessness. You can reach out to case managers at shelters or where people experiencing homelessness might still be connected or spending time. Healthcare providers, we have a medical legal partnership with Healthcare for the Homeless, so we're in contact with a lot of the health providers there. Social media has been an effective way, connecting through email, word of mouth. A lot of folks, that we receive phone calls from say that we're one of the only places answering the phone right now, and that they heard that through a friend or through a client or former client. So that's been really great to be able to connect with folks. Also, you can connect with your state anti-hunger organizations, which I've posted the link on the FRAC website. Know Your Rights videos. There's a whole host of different ways of connecting now that we're all working remotely. Next slide. So I started the presentation by saying that there wasn't additional funding in the legislation for an extra TANF benefit, like a one-time payment or an emergency benefit. The HHS guidance does suggest that states can use so states are allowed to carry over federal TANF dollars if it's not spent from year to year, and can build up reserves with this money and use that to spend later. So the HHS guidance does say that this is one use that states can do. Maryland has not done this, but some states are using their unspent reserves to provide like a one-time or emergency benefit, and the usual requirements of data reporting and child support, work activity don't apply usually to that. So that's nice. The next slide, please. And this is not related to TANF, but I just wanted to mention, a lot of folks are trying to avoid grocery stores right now. So it's great if you can to, order groceries online for delivery or pickup, but there's actually certain restrictions that apply if you receive, or not restrictions, the retailers have to be authorized to allow someone to use their SNAP or EBT card to make these purchases. So at least in Maryland, there's only one retailer that I know of that right now you can order online using your EBT card. I put the website on here so you can check depending on what state you live in, but some states are participating in a pilot program. I think New York, Washington, Alabama, Iowa, Oregon, and Nebraska, as recent as April, are participating in that. And there's a number of states that have been approved to move forward in upcoming months, April, later this month, and May. So the FNF's website would have more information about that. So just in the interest of time, I'll stop it there, but happy to answer questions after. Thank you.
Thank you, Michelle. It's very helpful. And what we'd like to do at this point is I'm going to stop the share here in a second. And what I'd like to do is go into our question mode. And Joy, look, why don't we start with, from the perspective of many of the audience members, what are some things we can do to make it easier to do the administration, if you know, based on the computer issues, the phone issues, and so forth, from your perspective?
Well, I thought about it. First, I saw a question for people who can't text and who can't have access to like online, maybe through the phone or the mail system. Like maybe if they could hire some more people to do paperwork, like do it the old-fashioned way, mail in some of the applications, or just to keep in contact. Because if you know they want you to come in person, that's completely impossible. So. Or even with maybe the phone line, I saw they were saying, what if people were running out of minutes? So that's the only thing I could maybe think of, is going through the mail for the people who absolutely have no other way to contact these different places.
Okay, great. Thank you. And Elizabeth, at this point, can, you know, the information relative to immigrants' rights and the testing, can you expand upon some of the issues there in that regard?
Sure. So, I mean, I think in all times, undocumented immigrants are eligible for very restricted set of benefits. Someone asked specifically what, and it's really emergency Medicaid. So if you're in a life-threatening situation and need to go to the hospital, and then children are available for nutrition programs without regard to immigration status. Some nutrition programs, WIC and school meals, not SNAP. But in many cases, at least the mixed status families have been able, that the children can receive benefits if they're citizens, even if their parents are not. And I think so with the stimulus payments, really, it is quite, you know, egregious and challenging that the children are not able to access the benefit if even one of their parents doesn't have a social security number. So, and then I think a lot of it, again, is because there's been concern, you know, public charge is this new rule that the administration actually implemented just before everything blew up, where if immigrants who are eligible for health care or nutrition or cash benefits or housing, if they access them, that can be held against them for if they're applying for a green card later. Very, very few people are eligible for those benefits who don't have a green card, at least already. But it's just created a climate of fear and concern. People don't know what they can get. People don't know if it'll be held against them, or maybe they want to reunite with family in the future who are abroad, and people are just deeply concerned that they'll be penalized for getting what they need to support themselves and their families, which is deeply concerning.
Thank you, Elizabeth. Greg, a question one of the audience members asked is, what if a low-income individual had two jobs just to be able to pay bills, and one job is still working full-time, but the second job, you know, is not due to the pandemic? Can they still get any assistance with unemployment? We don't have a specific state, but as a generality.
I think that'd be difficult if you're still working full-time on one job. I mean, I acknowledge that people are doubling up, sometimes tripling up just to make ends meet. I think if you're working full-time, you may not qualify for unemployment to begin with. And so the new pandemic programs may not be of assistance.
Michelle, are you seeing similar type of activity in Maryland with some of your applicants?
With regard to unemployment insurance?
Yes, and multiple jobs and running into limitations.
The issue that Joy raised, I've heard about as well, difficulties with the online application where you go to apply, and if you've had more than 3 jobs in the last 18 months, being prompted to call, and then just either getting cut off or hold times, not being able to actually file, and then having to start all over again and not being able to submit the application.
Okay. All right. Well, thank you. And then just looking over, we've got a whole series of questions. We won't be able to get to all of them, but we will be posting the slides for all the panelists, as well as a copy of the recording that will be provided after our presentation today. The one question I really have for all of you, just generally overall, is, well, now we're here, and we know that we're going to go through probably a staggered reentry. And what other options or what other policy issues would you suggest advancing to really make a difference going forward? Because we've got a moment of opportunity now with the pandemic to really see is just really the type of safety net public benefit portfolio of options that we think best fit society at this point in time. Any thoughts on that? And we'll start with just work. Elizabeth, we'll start with you and just kind of go around the horn here, please.
Sure. I mean, I think there's, as said, even if the health impact is short-lived, which we hope it is, the economic impact will be lasting for many, many people. And so making sure that our supports respond appropriately. And I think we need, through everything, more SNAP, more Medicaid coverage. But yeah, people need cash assistance. There was no boost to TANF. The stimulus is a one-time payment. People are going to need more money in the near future, thinking about that. And again, just everything that we've raised today about the implementation side, I think when Congress tries to get, really fine and make sure they're only targeting the people who exactly need it or they think need it, what you wind up is with these very complicated systems where it's just really hard. Literally I'm looking at all these questions that we got and half of them I can't answer, and I spend, 40 hours a week trying to figure this stuff out. And if you're someone who's just lost their job, how you're supposed to figure it out is just really hard to wrap your head around.
Absolutely. Well, thank you. Michelle, from your perspective?
Yeah, thanks. I think, the culture in accessing benefits for SNAP and TANF and Medicaid, it's very heavily reliant on in-person, face-to-face meetings, even if that's not a requirement in the regulations to have that in-person contact. That's just the culture. So anything that, they need a verification or a question, you'll get a general notice that says, please come in on this date for your in-person meeting. It might not even say what the purpose of the meeting is. And if you miss that meeting in person, your benefits usually close out almost immediately. Of course, that's unlawful. And we can deal with that as we do on appeal, but just this very heavy in-person face-to-face meetings as being the only way of communicating is, I think what we're learning now is that you don't need to meet with benefit recipients in person in order to establish eligibility. You don't need necessarily always a third-party verification of everything someone says to find someone eligible. Just some flexibility with a lot of these requirements. What we're seeing now is will result in folks getting access much quicker than having to file an appeal, wait several months just to establish eligibility.
Okay, great. Thank you. And Joy, how about you? And then we'll turn to Greg to close out our session today.
Well, kind of what Ms. Michelle was saying of how the communication is really bad. Because even before all this stuff hit, it was like, I had a number they gave me to call them. The number didn't work. I've called in multiple times. You can never get anybody on the phone. And even the mail system, if you're a person who doesn't have a set place to live, like even that, you can't get the information and they'll shut it off because you didn't receive that piece of mail. So I think communication is like something they really need to work on.
Great. Thank you, Joy. And Greg,
Thank you.
any thoughts from your perspective?
I would echo what folks have already said. A couple of additional things occur to me. Like I said in my last slide, applicants and recipients for benefits, sorely needed benefits who have disabilities, are really going to be left in the lurch during this pandemic. Analogous to situations of special education students who needed that personal interaction to fulfill the goals of their IEPs. Applicants and recipients of disabilities will often need some sort of personal interaction to make sure they get reasonable accommodation so that they can navigate their way through complicated eligibility processes. That's going to be greatly aggravated here. And I think that the fissures in the eligibility systems that have been there for generations are greatly exposed here. The needlessly complicated verification requirements, needlessly complicated application documents, let alone for persons with disabilities, for everyone. Those are coming to the forefront as real access barriers. And you know, the lack of staffing, the lack of funding, the lack of resources for public benefits agencies, unemployment insurance agencies, state departments of labor, those are all coming to the surface that have been long simmering problems, and they're going to get worse.
Thank you, Greg. And at this point, what I'd like to do is thank our entire panel, Joy Flower, Elizabeth Lower-Bash, Greg Bass, and Michelle Medeo for their great presentations. We hope you have enjoyed the seminar. We're out of time at this point, but please consider making a donation to our section of the American Bar at americanbar.org /donate CRSJ, so that we can continue to bring you these free rapid response programs. Thank you to all our co-sponsors, which are too numerous to list at this time. And thank you to our panelists for sharing your knowledge, and for you, the audience, for your participation and interest in providing advocacy and support to those applicants and recipients of public benefits. For more than 5 years, the section and its members have worked on hundreds of issues addressing a broad range of civil rights, civil liberties, and international human rights. Join us at americanbar.org /CRSJ. Thank you for your participation today, and we wish you well. Stay safe.